Senate Bill 98 makes sense as policy that when you appeal to the district court, the burden of proof maintains with the county. That's the whole part of this bill. It makes complete sense. It's reasonable and consistent with current law on the initial trier effect before the Board of Tax Appeals, the same thing with the district court. So, Madam Chair, we'd stand for any questions you have, but I know you have other proponent testimony as well.
Thank you, Randy. Committee, any questions? Senator Alley.
Thank you, Madam Chair, and thank you, Randy. The question I have, would, during that new trial, as we say in district court, would the results of the appeal to the BOTA and your appeal to the, let's just go from first time you go appeal, second time appeal, up to BOTA, would those results be presented?
So in the appeal to the Court of Appeals, it's that district court of opinion that is actually appealed. You're appealing that district court opinion, so it's that trier of fact, those findings by the court, the district court, is what is appealed to the Court of Appeals. So the Court of Appeals will look at that cold record in making their determination.
But in the new trial, will those results be presented?
So the Board of Tax Appeals, when you appeal to the district court, you have a whole new hearing. So the previous trier of fact is inconsequential during that new hearing before the district court. You have a new trier of fact, new evidence, new facts submitted, new testimony. This is a whole new trial. For that reason, it makes sense for policy reasons for the county to maintain that burden of proof.
Thank you.
Committee, any other questions? Randy, I have a question on the other section that extends the 180 days on the BOTA appointment. Would you have any reservations of if we have an issue. We used to have 5 judges. Now we've only got 3. Last year we ran into a shortage for a couple of reasons, and we're about to have that same situation again. We have 2 people appointed. One is retiring at April 15th. So I'm asking the conferees if they could quickly comment to us amending the bill to include language that would allow past judges to contract and or their positions to be extended if reasonable efforts have been made to replace and appoint.
Well, we think that makes all the sense in the world. This has been an ongoing problem to find adequate hearers of fact at the Board of Tax Appeals. I don't say that that's going to change anytime soon. I think this is a good fix.
Thank you. Committee, any other questions? Seeing none, thank you, Randy.
Thank you.
Our next conferee is Eric Stafford.
Good morning, Madam Chair and committee members. Thank you for the opportunity to be here this morning in support of Senate Bill 98. Randy did a great job, as always, summarizing what the bill does. Pretty simple fix in our view in terms of just trying to clarify what Kansas law is. Probably oversight from 2014 to not get that put into statute at the time. Just to be consistent. To your question, Madam Chair, no objections to that. We can get some additional feedback from our folks if need be, whether it's extending the time frame or just allowing people to serve until that new appointment is made, just to ensure that we don't have those gaps where people have their term expire and then we're just left with an unfunctioning body, government body, because we don't have enough people in place yet. So, but what's in here is perfectly acceptable. And then if you want any other ideas, we're happy to seek those as well. But ask for your support on Senate Bill 98. Happy to answer any questions.
Committee, any questions? Senator Corson.
I probably should have asked this to the revisor, so I'm kicking myself for having not done that. And my question is just as a kind of a rookie question to help me understand the order of appeals. It goes from BOTA, and then am I correct that you have to go to district court before you can go to Court of Appeals?
No, Senator, Madam Chair, you go to BOTA, you can go Court of Appeals, but something that was added, was that 2014 when de novo was added? So de novo, 15, okay. So what was happening at the time, if I remember right, there were some cases where BOTA was not looking at all of the evidence. And so taxpayers saying they're not including everything, they're not looking at everything. So we added a provision that if you don't feel like you got a fair shake in front of BOTA, you had the de novo back to the district court. So you can go Court of Appeals if you felt like you had a fair shake at BOTA, or you can file trial de novo and go back to district court.
That's a very helpful explanation. I very much appreciated it. Thank you.
And it may have been 14, those years are starting to run.
Yeah,
to me.
around there.
I know I was the vice chair, it was a very lengthy bill, so thank you. Any other questions, committee? Okay, seeing none,
Thank
thank
you.
you. Dave Trobert?
Thank you, Madam Chair, members of the committee. Dave Trobert for Kansas Policy Institute. Boy, he's tall. I'll keep this really brief. The reason that this is necessary, in addition to fixing something that should have been there, is that history shows us that much of what takes place in front of BOTA gets overturned. A lot of the county positions. We did a survey or an open records request on 5.5 years of cases in BOTA. About 4,600 cases over that period, 71% were found in favor, either fully or partially in favor of the taxpayer. 71% is an enormous overturn rate. And part of what happens is there's a game that gets played where they see how far they can go. A lot of these get settled just right before. So it's pretty clear that there's a lot of abuse in the appeals process, not so much from BOTA, but from counties, and this needs to be corrected. On the extension of the time frame, I would concur with the previous folks. We shouldn't rush. You should have the time you need to find the right people to replace. So we're fine with extending the time frame.
Or possible contracting? Yep.
Oh, or that, yeah.
Okay, thank you. Committee, any other questions? Oh, Senator Baumgardner.
Sorry, Madam Chair. Quick question. In looking at the chart in what you sent in, so the property tax, we're talking about individual homeowners predominantly with regard to?
This is a combination. This is, I think this went before the regular division. So these were not small claims.
Okay. Thank you. Thank you, Madam Chair.
Thank you. Committee, any other questions? Seeing none, thank you.
Thanks.
Is there anybody else that would like to testify for the bill? Shahira, I've been practicing your name and you're written only. So, thank you. Committee, we do have an opponent to the bill, Sean Robertson. He is written only. Is there anybody else that would like to testify against the bill? Seeing none. Neutral testimony, Jay Hall, and Jay is online.
Thank you, Madam Chair. I will be brief. I will address your question first. KAC does not have an issue with BOTA either contracting with the judges that were previous judges. We actually think extending those timelines is a good idea, and we would support that measure. As to the other portion, I'd encourage you obviously to read my testimony, but under Kansas law, only the taxpayer may appeal to the district court in a tax appeal. And traditionally on appeal in a court of law, the burden rests with the party that is appealing that prior decision and bringing the action. And counties are barred from bringing the action. And with that, I would answer any questions that the body may have.
Betty, any questions? Jay, would you consider the initial action was actually the county's decision on the appraisal?
The initial action, yeah, the initial action is, of course, the county's appraisal, and the taxpayer appeals to the county, and the county has the local process followed by the process in front of a district, and then finally going up to BOTA. And then at that point, the the taxpayer can appeal to the district court after that BOTA hearing.
So if I understand you, you say that the county never is the one forcing it to court. However, if there's a disagreement, it could be considered that the county is forcing it to court, even though they didn't ask for it, but because an agreement was not reached.
If an agreement was, if it was not settled prior to the BOTA hearing, then yes, it would go up to BOTA, but the county cannot bring the action at the district court.
Okay, committee, any other questions? Senator Alley.
Thank you. Sean Robinson, is he here? Or is he not online? Okay. I do not have a question with him, but perhaps someone could, in the audience could answer. You do the first appeal with the county appraiser. The second appeal is usually with, I'm talking about for a residential house now. The second appeal, you go to a independent, somebody to hear that independently, and that's usually from a county that's adjacent to yours. But on that appeal, does it not say that the burden of proof is on the county? Because the county has to present first, the county presents that. That's maybe a little bit different than what Sean had said in his written testimony. Is that correct? I guess is my question. Anybody know that?
Randy, did you want to?
That is correct, Madam Chair. That is correct. They initially appeal an informal process before the appraiser. And then if it is not settled at that point, or if the taxpayer is unsatisfied, then it goes to what's called a hearing officer or a hearing panel in an adjacent county. The burden of proof remains with the county at that point. And then it would proceed from that to the BOTA level, whether it's a small claims or the expedited hearing division. And that would be heard at BOTA, where again, the burden of proof is on the county.
Oh, and the reason for that I questioned that was it said that the burden of proof in a court falls with few exceptions to the person bringing the action. In that case, that is what you said was correct. Thank you.
Thank you. Randy, did you have another comment?
Well, I would just say that Amelia is probably our resident expert on this entire process, but we do break it down into the informal process. That's all before BOTA, before the Board of Tax Appeals. And then the formal process is kind of that thereafter. And it's our argument that just as it's appropriate for the county to maintain the burden of proof before the Board of Tax Appeals, in that new hearing, they should maintain the burden of proof before the district court.
Thank you. Committee, are there any other questions for Jay? Thank you. Oh, Senator Corson.
What is the burden of proof? What is that standard?
Okay.
Thank you.
Would you address so they can hear it for the record? Thank you.
Madam Chair, the question was, what is the burden of proof? What is the standard of proof? It's the preponderance of the evidence.
Any other questions for Jay? Seeing none, thank you, Jay.
Thank you.
Is there anybody else that would like to testify against the bill? If not, we'll close the hearing on Senate Bill 98, open the hearing on Senate Bill 119. Amelia, would you mind? Thank you.
Madam Chair, members of the committee, Senate Bill number 119 relates to property taxation, including valuation appeals, appraisal standards, county appraisers, and the State Board of Tax Appeals. I'm going to go through this hopefully briefly, section by section. And if you have questions when I'm finished, please feel free. Section 1 of the bill would amend KSA 19432 to provide for notice and an opportunity to be heard prior to the removal of a person from the county appraiser eligibility list. That eligibility list is a list maintained by the Director of Property Valuation. The bill would also require that the Board of County Commissioners or governing body of a unified government notify the Director of Property Valuation when a person no longer holds the office of county appraiser. If the person does not complete their 4-year term to which they have been appointed, then the notice should also include the reason for their non-completion of the term unless otherwise precluded by law. and the director shall also make a notation on the eligibility list. Section 2 would amend 74-24-26, also relating to the State Board of Tax Appeals. It would change the time to request a full and complete opinion. Currently, after the Board of Tax Appeals issues a summary decision, any aggrieved party may request a full and complete opinion be issued by the board. They're required to do that within 14 days of receiving the board's decision. The bill would amend that time frame to extend it to 21 days, and it would also, that time would start running from the date of service of the board's decision. The bill would also require that the board serve an order or notice upon a party or their attorney by transmission of a copy by electronic means if the party has requested and consented to service by electronic means. Section 3 would amend 74-24-33F, and it has to do with valuation appeals, and it would provide that the small claims hearing officer shall not increase the appraised value of a property in an evaluation appeal to an amount greater than the county appraiser's decision from which the taxpayer appealed. Consistent with that, when an appeal is made from small claims to the regular division of the board shall not increase the appraised valuation to an amount greater than that which was decided by the county appraiser and appealed to small claims. Section 4 would amend 79-505. This relates to appraisal standards. This would require that appraiser directives adopted by the Director of Property Valuation for the performance of appraisals for property tax purposes, that those appraisals be performed in compliance with the Uniform Standards of Professional Appraisal Practice, also referred to as USPAP. Currently, the Director of Property Valuation may also require compliance with additional standards if a determination is made in writing that those standards are required. The bill adds a requirement that such additional standards shall not conflict with USPAP. The bill also removes the Director's rules and regulations authority relating to prescribing standards for the performance of appraisals. Section 5 would amend 79-14-48 to provide the county appraiser shall not increase the appraised valuation of a property as the result of an informal meeting. Section 6 would amend 79-1609, that again, the board should not increase the appraised valuation of a property in a valuation appeal. And Section 7 would amend 79-2005 to, again, this is the payment under protest statute. The language there is very similar to what in some of the previous sections. To provide that the county appraiser shall not increase the appraised valuation as the result of an informal meeting, and also that the Board of Tax Appeals shall not increase the appraised value to an amount greater than the appraised value that was reflected by the county appraiser in their notification that was appealed from. And I would be happy to stand for questions.
Thank you, Amelia. Committee questions? Amelia, these were the bills that passed 40-0 in the Senate last year, all of them. So I just wanted the committee to be aware of it. Okay, thank you. Our first conferee, Randy Stuckey. We're going to feel like deja vu in this bill committee.
Thank you, Madam Chair. Certainly, we came before this committee last year and testified on all these bills that this bill represents. And it may seem like there's a lot going on here, but really these are just procedural changes that we think strengthen the property tax appeal system in the state of Kansas. Property tax valuations and increasing valuations have been an ongoing problem for the grain and biofuels industries in Kansas. Very large, complex properties that have appealed oftentimes in recent years their property valuations. So we have a sharp interest in this issue, and all of the bills that are represented in this one bill that clearly passed the Senate with no opposition, I think, last year. So for that reason, we believe this is all good policy changes and would stand in support of the bill. Hopefully you would as well. Would stand for any questions at the appropriate time.
Thank you, Randy.
Thank you.
Committee, any questions? Thank you. Eric Stafford?
Thank you, Madam Chair, members of the committee. Eric Stafford from the Kansas Chamber in support of Senate Bill 119. I'd probably call it more Groundhog Day than deja vu being here, but we are thankful for the opportunity to speak in support of this bill. As the chair said, all of these passed 40-0 last year. In our view, pretty non-controversial cleanup language. The eligible appraiser list, pretty self-explanatory. If somebody's terminated in one county and they're unfit to serve in that capacity, then they should not be considered and have a process to be removed from the list of eligible appraisers. This committee last year had some questions on the ability for an individual to appeal that type of decision, and so there was some clarification added for the actual appraiser to go through that process. I believe that language is in here right now as well. The timing of receiving a full and complete opinion, probably the biggest piece for us in this one is preventing BOTA from increasing valuation during an appeal. We have, there was testimony given to this committee, I think it was 2 or 3 years ago, from a representative from BOTA who said, they were asked the question, can you increase valuations higher than what the taxpayer is appealing? And they said, no, we don't have that authority, but we do have specific examples from taxpayers who went to BOTA to appeal a valuation and then left with a valuation higher than what they were appealing. That is not fair. That is not right. This is, again, I think, putting in statute what is the intention or should be the intention of law. So happy to answer any questions. The use PAT piece is good as well. That's a nationally recognized performance standards for the appraisal profession, and having that reference in statute is good as well for the profession. So happy to answer any questions at the appropriate time.
Committee, any questions? I have a question. It probably should have been on the last bill if we do make the amendment instead of this bill. But one of the things that came up when we were having discussion the other day in the committee was there's not all they have to do, a BOTA new member, is to take the test. They don't have to pass the test. Would you have any comments as to if we were to amend to address that?
Yeah, and I think,
This bill, but the previous bill.
yeah, I think that is perfectly fine and acceptable and encouraged. Yeah, I think, you know, that the questions that have come up yesterday, last week, you know, through the BOTA process, as we knew we had the vacancies, you know, there's language in statute to give the governor, there's as we've communicated with the governor's office leading up to the appointment of Mr. Marks to BOTA and our objections to that. So they were aware. Their comments, they were having a hard time finding qualified people based on the requirements, but there's language in there that gives them the out to, you know, make the reasonable effort and then find somebody else. But I think there were the timing issues that you alluded to that kind of hamstrung everything, and then COVID came into play and everything just got all messed up. So yeah, I think anything to strengthen the qualifications. And if you know, Ms. Powell, you were asked about, you know, what experience does she have in the appraisers, and she didn't have any, but she's a CPA, which is a requirement in statute for BOTA. There's congressional district requirements. You know, I think as long as the governor's office makes that due diligence to try to find somebody and then they can't, they have that flexibility to get somebody who it would be qualified, who, to your point, could pass a test on appraisal issues. So no, I think that'd be welcome. And but you know, ultimately overall, we just want qualified people who will rule according to Kansas law. You know, give taxpayers a fair shake. Same thing as what we seek in workers' compensation, unemployment insurance. We just, what is the law, and interpret it accordingly. So.
Thank you. Committee, any other questions? Thank you, Eric.
Thank you.
Dave Trobert?
Oh, I'm sorry, it went off. Thank you. The complying with USPAP gets to the essence of the dark store issue, the controversy, because this would prohibit county appraisers from adopting anything that's not consistent with USPAP. There are those, certainly in my home county of Johnson County, that have gone before the Board of Tax Appeals, and according to the Tax Appeals Board, they say the county is advocating for a change in the law. They specifically said that the county's position is contrary to the law, and yet they continue to try to push this. They're not the only ones. There have been other appraisers. There have been, including the Mr. Marks, who was here yesterday, certainly has advocated saying that the law is wrong. And anyone's entitled to that opinion, but this is the place, the legislature is the place to try to change the law, not the Board of Tax Appeals or at the county appraiser level. I'd also comment on notifying when notifying PVD when an appraiser is no longer employed. We cite in our testimony a specific example of an appraiser who left one county, got hired by another one, and there's a quote in here that's from someone who replaced that appraiser saying, this is the second time Reedy has followed him into a job, and the second time she has had to clean up after him. Now, that county appraiser got hired in another Kansas county. So there is good history reasons for these changes, and we encourage you to support them all, and happy to stand for questions.
Thank you. Committee, any questions? Seeing none, thank you.
Thank you.
Is there anybody else that would like to testify for the bill? Committee, Shahira has submitted written testimony. We have one opponent for the bill, Sean Robertson. He has written testimony also. Would anybody like to testify against the bill? Seeing none, is Jay Hall we have as neutral testimony. Jay, are you still online?
I'm still here, Madam Chair. Thank you very much. And KAC doesn't have opposition to the majority of the items in this bill, and I'll run over those very quickly. BOTA opinion, the extension from 14 days to 21 days, we don't oppose that. We really only are just pointing out that this may add some time to the time it takes to process other appeals, because most of the time people will wait for that full decision before they file their appeal. We support the electronic notice section. We think that's good policy. We don't oppose changing to the USPAP. We have no opposition to that. And we're neutral on removing names from the appraiser eligibility list. There is some concern, even with the appeal process in there, that there may be unintended consequences. But we don't have opposition to that portion of the bill. We are just neutral because we're not really sure how that will shake out. We do have, with the valuation increase prohibition on appeal, the purpose of tax appeals is really to get the valuation correct. Constitutionally, fair market value demands accuracy, whether that final accurate value is higher or lower than the valuation that's given by the appraiser. And so that's really our concern when it comes to that particular section of the bill. And with that, I would be happy to stand for questions.
Thank you, Jay. Committee, any questions? Seeing none, thank you.
Thank you.
Jay, I would ask you really quickly, do you have concern or heartburn if we were to amend a bill, I won't say which bill, to put in parameters that the person being appointed to BOTA actually pass the test, not just take the test?
For are you talking about for appointments to the BOTA board?
Yes.
I don't have any initial heartburn on that particular issue. I don't think there are necessarily problems with that. I do think, just in thinking about this out loud here, I do wonder if it would cause problems as far as individuals that are, because we're already having some problems finding eligible individuals for that. But that would be maybe the only concern that I would have, is just that may decrease the number of people, but I don't think we have a problem with that.
Okay. Committee, any other questions? Thank you, Jay.
Thank you.
Minutes. I'm going to, is there anybody else that would like to testify neutral? Seeing none, I'm going to close the hearing on Senate Bill 119. And committee, I'm going to draw your attention to Senate Bill 71, the Eisenhower bill that we heard yesterday. Committee, what are your wishes on the bill? Senator Clays.
Thank you, Madam Chair. I move that we recommend Senate Bill 71 favorably for passage.
Senator Baumgardner.
Thank you, Madam Chair. I second the motion.
Okay, it is, I'm wondering if this is consent calendar material, or would you rather like to carry it? He'd probably like to carry it on the floor. The motion has been that we will move the bill out favorably for passage, made by Senator Clays, seconded by Senator Baumgardner. Any discussion on the motion? Seeing none, all those in favor say aye. Aye. All those opposed, same sign or nay. Motion carries. Thank you, committee. I would give you the plan of attack for tomorrow. We do have a hearing on another bill tomorrow, and then we will work some bills in the afternoon. My plan is to look at 98, 119, 46, 50, 72, 147, possibly 87 and 23. I know we're looking for more information before we work those bills. Committee, any questions? Any other business to be brought before the committee? Seeing none, we're adjourned. Thank you.